Welcome, everybody. Yeah, I'm Jeff Goldman. I've been practicing immigration law for 32 years. It's all I do. My law firm is located just outside of Boston, although we represent foreign nationals from all over the globe and certainly all over the United States. We are mostly representing companies who are legally hiring foreign nationals, but we represent individual foreign nationals by the hundreds and hundreds, people who are trying to figure out their own path in the immigration landscape. So I'm excited to partner with Danielle on everything to do with build and for this webinar in particular.
Amazing. Thanks, Jeff. I was speaking to myself earlier because we hadn't started the webinar. So thank you all for bearing with us as we started a couple of minutes late, but we're happy to have you here. I see quite a few names that I recognize who represent companies that currently work with Build and a few new names as well. We, as always, have the Q&A open here so you can ask questions as we go. Our goal today is talk through, of course, some of the Plan B solutions. Jeff and I are obsessed with creative pathways, so we're going to dive into a little bit about the cap-exempt H-1B, where it is right now, some of the intricacies going on in the H-1B world post-lottery, and then we'll dig into a few more programs that we are launching and already have going on. And Jeff will talk us through some of the other strategies he's advising given the current ecosystem right now. So why don't we dig in to set ourselves with what is going on in the current moment. Jeff, if you could give us a sense of what is happening for just 3 weeks post lottery selection, so we have a pretty good sense at this moment. You're on the ground at your firm. If you could say what you're experiencing and what you're hearing from folks, that would be great.
Yeah. Well, my firm filed over 350 H-1B registrations in the lottery, and we had a 51% success rate. I think that is right on the national average. Right around 50% of those who registered for the H-1B lottery were selected. Quick reminder, just because you were selected doesn't mean you're done. It means your employer can file an H-1B petition no later than June 30th. And we're very busy getting ready for these petitions, preparing these petitions. We're already filing a lot of the petitions. And every week we keep getting more because people who never were in touch with us and registered themselves for the lottery and won, they're reaching out now for help. So that's keeping my office pretty busy.
Did you
As
see
a rem-
level 4 wages get selected at a much higher rate? What was based on the weighted lottery? What did you experience? What are companies experiencing? Do you have any sense of those percentages?
yeah, it wasn't as high as I thought. Our level 4 wage registrations had a 69% success
Mhm.
rate. I would have thought it would be much higher. I would have thought the national average would have been much higher, but I don't think it was anywhere. I think it's in the high 60s is where most of the lawyers are talking about. And yes, definitely our level 3 wages had the next highest rate, and our level 2 wages did actually pretty well. Our level 1 wages, I think we filed possibly 40 level 1 wage petitions, and only 3 of them were selected. So that was really low, but that is sort of what the Immigration Service said would happen. And unfortunately, there never was a court decision prior to the lottery on whether it was legal for the federal government to initiate a new wage-based H-1B lottery favoring the higher wages. I happen to think it's completely illegal, and I think a court will eventually strike it down, but it wasn't in time for this H-1B lottery. Just a quick update on the other major issue with H-1Bs is the $100,000 fee being charged only to those situations where the foreign national who won the lottery is outside the United States or happens to be inside the US, but USCIS says you have to leave and get a visa and come back because you were not maintaining proper status. And therefore will approve the H-1B, but only if you leave and come back. Those are the people who must pay the $100,000 fee. And again, litigation is underway. I think there's a strong chance of winning that litigation to prove that that $100,000 fee is not legal, but it's not here yet. And so right now, there is still in place the $100,000 fee for those who are outside the United States.
The leaders of that litigation, or at least one of the three cases that are active against the $100,000 fee, Jesse Bless used to work for Jeff, and he is working on that litigation with Greg Siskind, one of the other lead litigators in the country in the immigration space. And we were with him recently down in Texas at a conference, and Jesse and Greg have said that they feel that there is about a 65% chance of success in their case in California in the coming weeks, which is a really interesting. Nothing's guaranteed was their point, but they feel like they have a very strong case, and there's more than a 50% likelihood that this ultimately is turned over because of the Supreme Court's decision to treat, because of recent immigration rulings. And so we'll see what happens. They're trying to prove that this $100,000 fee is a tax, and that's not something that can be implemented by the president in a proclamation. So we'll see what happens there. That's sort of the update on that end. We have at Build, we have a few companies that are working with us now, actively trying to file with paying that $100,000 fee, which is quite interesting. We're working with Jeff's firm on those cases. About 80 cases nationally, we hear, have actually been filed successfully in paying that $100,000 fee. So that's a very small amount given how many people typically come from outside the US. I think it's worth in this moment, post lottery, what we're discussing today is creative strategies. So, Jeff, one question to you is right now, there are companies coming to you who typically would go down the H-1B route. They are trying to bring people from outside of the United States. What are you advising right now to those companies, and what options are you putting on the table?
Right. Well, because these companies, for the most part, H-1B is not available because they missed the lottery or they did enter the lottery, but they lost. And of course, we're going to be talking about cap-exempt H-1Bs as a major possibility for these companies. But before we get to that, I do want to bring up a few other things that we suggest. We suggest they certainly be investigated and considered. The first would be an L1 visa. And this is for a multinational company where there's a company outside the US, a company inside the US, and there's a qualifying relationship, which basically means common ownership between the two. And if you, the foreign national, have worked for at least one full year outside the US for either the foreign entity or the US entity, you are eligible to pursue an L1 to be transferred to the United States. But the key thing is you must have worked outside the US for 1 year out of the prior 3 years. This is a strategy that should not be ignored because if your ultimate goal is a green card, and there's a horrific backlog for green cards for people from India and China. If I were from India or China, I would consider leaving the US for a year, working outside the US, and then transferring myself to the US entity. Even if I had to create the US entity, that's possible. So there's certainly a strategy worth considering. Plus,
Now, what about losing H-1B is one thing, but what about companies that have folks outside the US they've wanted to bring here? Are you seeing, typically if they would have brought them here on an H-1B, are you seeing companies set up international entities to facilitate an L1? And how is that possible, or is there scrutiny over that?
well, there will be scrutiny, but it's definitely possible. We've done it many times over the years when there were no H-1Bs. Consider this. There are a lot of talented people out there who already had been working for a U.S. entity for 1 year while they were outside the U.S. And maybe there isn't a multinational company, but you can create one by opening an office outside the U.S. Let's say the multinational is in India, and is an Indian citizen, but the U.S. entity they've been working for 1 year doesn't want to open an entity in India. They don't have to. They can open it anywhere, Canada, Mexico, London, anywhere. And now there is a multinational company. And it's true that the foreign national has been working for either the company outside the U.S. or the U.S. company for at least 1 year while they were physically outside. So yes, we are seeing companies considering opening up offices outside the U.S., but only if it strategically makes sense for the company.
Yeah. What else are you advising to folks who have not been able to bring people here because of the $100,000 fee?
You need to consider the O1 visa opportunity. O1 is for people who are extraordinary in their field, which means that they've risen to be among the very top in their field. The U.S. Immigration Service has regulations that state there are 8 criteria that the U.S. immigration officer should consider, and the foreign national has to prove that he or she meets at least 3 of the 8 criteria. The bar isn't, it's not impossible. There are many people out there who either do meet at least 3 of the criteria or could with a little effort and good luck. Basically, the criteria are: have you published any scholarly articles?
Jeff,
Have
before
you,
you go into those criteria, because this
yeah,
is Immigration 301, and I see a lot of companies on here who are not foreign nationals themselves, but are actually trying to figure out solutions for their foreign nationals. I want to ask you one question to dig a bit deeper, which is one, in the O1 space, what is going on right now from an approval perspective? Because obviously it is a very challenging given that there's an influx of people applying for O1s. And number two, what are some strategies? Is it possible for companies to help build those 8 criteria? What have you seen companies do to actually potentially assist their employees in building a better case for an O?
a lot. Companies are making that effort because if they really want the foreign national and they are not going to pay the $100,000 fee, and or they didn't win the lottery, and or the cap exempt H-1B does not make sense for them, they are helping their foreign national employees or potential employees reach the goals, at least 3 of the criteria to qualify for an O. So there are things that the U.S. employer can help the foreign national do, and there are things the foreign national can do themselves. For instance, one of the 8 criteria is being a judge or reviewer of the work of other professionals. So it turns out that it's not that difficult to use connections. Both the employer or the employee could use connections to become a judge of a hackathon or to become a judge of a business plan competition. Some of my clients have been very creative, and they have, while they were outside the US, been able to get to work for a US or international based venture capital company reviewing applications for funding that are relevant to their field. All of these are excellent evidence that you have been the judge or reviewer of the work of others, and it can be accomplished with some push. One of the criteria is: have you been interviewed by major media who's done a story about you? Well, major media turns out to be any online. I know
Sorry.
it turns out that major media is any online or hard copy media that has wide circulation. So there's a lot of online media with millions of hits a year. That's wide circulation, and we can prove the number of hits or downloads. And yes, they're not interviewing everybody, but so many people on this call are very interesting people with interesting careers, interesting pathways, and interesting companies that want them. And I think it's a very interesting story. I would like to read a story about how people have launched their careers and where they're going. So I think that's doable.
With companies, though, I mean, they could assist in obviously creating some of these publication opportunities, and obviously, if they're publishing about the company, including those foreign nationals in some of those publications as possible. Okay, so that's helpful to understand. And do you see an increase in denial rates in the O1 space or RFPs, given that we've been reading that nationally there are just an increase in those applications because of changes to the H-1B?
Yeah. Yeah. Well, we double checked what we've seen in the past 6 months, and even in the past 4 months. What we've seen is an increase, and we're filing hundreds of O1s over the last year. But just in the last 6 months, we've seen an increase in RFEs, but not an increase in denials. So it's a little bit harder.
Yep.
The U.S. Immigration Service is doubling down on their mission to scrutinize everything and be sure that the person truly is qualified. But when we respond to the RFE, in 98% of the cases, they're approving them. But I do think that on a national level, there's a huge increase in denials, mostly because people who are not qualified are filing because they don't know what else to do.
What else are you advising folks to consider for their employees? moment post lottery if they're not selected?
Well, I certainly want to mention the possibility of an E2 visa. An E2 is not for everybody. It's only for citizens of countries with whom the United States has a treaty for investment. Now, the first requirement is that the U.S. employer is owned at least 50% by the same nationality as the foreign national, and it must be a treaty with whom the U.S. has investment. Basically, it's the 60 countries we're the most friendly with, all the Western European countries and others around the world. It is not including China or India or Russia, but most of the Western players are all included. Now, what's interesting is this year we did two E2 petitions for people who were citizens of a country that can file an E2, but their employer was not. So they either had a U.S. employer that was not majority owned by any foreign national, or they were owned by foreign nationals, but not the right country, the foreign that the employee was a citizen of. So what we did is we had the foreign nationals open their own company in the U.S., a consulting company. And then their new U.S. entity was able to file an E2 petition, get it approved. The foreign national was able to enter the U.S. or change, if they were already in the U.S., they could change status to. And their first contract with their new company was with the bigger U.S. company that really needed them to work full time for them. And that has worked very well. So it's a lot more work, a little bit more expensive to pull off, but it certainly is a possibility. But you have to be a citizen of one of the 60 or so countries who are eligible for each.
That's
And
it.
that does take cooperation with the U.S. employer who wants you, because they have to agree to get you that way by entering into a contract with your new U.S. company rather than hiring you directly.
That's really interesting. Okay, so for employers, U.S. employers, they'd have to contract with that foreign national because they have to
Right.
be starting the entity in the U.S.
Correct.
Okay, understood. Okay, anything? I mean, do you want to talk about J ones? I think for a moment.
I do, because there's some very interesting news, maybe not in the past 6 months, but certainly in the past 18 months, some very interesting news about J1s. J1 are visas for cultural exchanges, where the foreign national is coming here to learn new things, such as being an intern at a U.S. company or a trainee and going through a training program at a U.S. company. What's new is that there's always been a J1 for people who are research scholars and doing research at a high level, but they were only for universities. But about 18 to 24 months ago, the US government made it very clear that they were now accepting J1 research scholars to be working at private entities. Well, this has opened up a whole new pathway for foreigners to be able to come here to work legally. And if you can't get the H-1B and you're not extraordinary enough for O1, and you're not working for a multinational company to get an L1, it is definitely worth considering a J1, because you could come for, I think, up to 2 or 3 years and even get extensions beyond that to come as a research scholar. There has to be a research component to the job, and the company has to employ other researchers, but it doesn't need to be a full-time research job. It can be a lot of work involved in addition to the research. So definitely something to consider.
Yeah. And I want to just take a moment to talk about our new J1 programs. We obviously, after the H-1B the H-1B proclamation in September, we found out that we obviously were, we have a lot of companies, including some on the call here, that have folks who are outside the United States that they typically would bring through our program, or we're trying to bring through our cap-exempt H-1B program, or wanted to enter into the lottery. A J1, this trainee that Jeff is talking about, when you hear the term trainee, many companies think, oh, this is an intern. This is someone very entry level. This is someone who we aren't sure we like at this point. We just want to test them out. While the latter may be true in some ways, and maybe this is someone you know who is an employee at will, or you're figuring out if this is someone who you want to invest in, the former is not necessarily the case. When we work now with some of our companies on a J1 trainee program, we are talking about helping many of their mid to senior level employees abroad come train in the US market. And what that means to us is they're not necessarily training on basic skills in the job itself. They're not, for example, hedge fund in Boston is not necessarily training their portfolio manager on how to trade, but rather they're training that portfolio manager on how to trade in the US markets with this US team to see if this is the right fit in the US for this person. And so this is the case that it can be made for a J1 for someone to come from abroad to work for your company. And it's something that we are now facilitating. We have two partners in the US that are J sponsor organizations, and we are partnered with them so we can essentially facilitate the J1 on behalf of your company. We're managing a pretty white glove service of doing the forms, managing the training plans that have to exist, and the cultural exchange programming that needs to exist to prove this is a cultural exchange program. And so that's really what we're doing. We're working with quite a few companies already. It's a newer program. We're officially getting this off the ground in this quarter. So we're excited to talk to any of you about some of that creative solution there, called the Build Cultural Exchange Program. So that's something to discuss. And I think the researcher category is something we're also going to be launching closer to Q4, but also very interesting and broader in some ways and longer term, right, Jeff? You can stay 5 years on that J1 researcher category versus a trainee. We're looking at about 9 months to 12 months on that trainee. But
It's actually 18 months for the trainee.
okay, we have programs that are
Oh,
shorter.
your programs.
Yeah. With the AIFS and Cultural Vistas, we do
Got it.
offer a 9 month and a 12-month
Okay,
program.
good.
It can be up to 18 months if desired. But what we're doing is we have many of these folks who are coming here on J1s. And if a company decides, well, this is that they've trained, they're really someone we do want to keep in the US on this team, that's when a change of status could be filed from J1 to H-1B or J1 to O1. And for folks who right now are stuck with this option of paying $100,000 fee, bringing people over here on a J1, seeing if they're worth an investment in a green card or in an H-1B is a good plan. That's what a
Yeah.
lot of our company partners in this scenario are doing. So that's definitely one J1 option you could speak about. I want to also talk about, while we're talking about new programs and for some of the folks on the call who might want to think about O1 agents, this is another program that we have launched. Jeff, you have an extensive experience in the O1 agent space. Would love to hear a little bit of background about O1 agents, and how this might be a solution for individuals who find themselves needing an agent. And then maybe even for companies who want to say, we don't want to incur risk right now, and we're not going to support an O1 or we're not hiring international talent. But if you have an agent and you have an O1, we could hire you.
Yeah. Well, the law makes it clear that someone who is extraordinary can file for an one, but he or she cannot sponsor themselves. They must be sponsored by either an employer or an agent. I think the original reason the Immigration Service added agents as a possible sponsor of O1 is because many people work through agents who are extraordinary. Artists, athletes, they work through agents, and they have to work for more than one particular employer at a time. So that is why the regulations permit an O1 to be sponsored by an agent. But it's also true that even business people and academics and scientists and researchers, they can also be sponsored by an O1 agent, which permits them to work for multiple employers at one time without the need of continuously filing multiple O1s with the U.S. Immigration Service. So who could be an O1 agent? Well, it has to be somebody in the business of being an agent. And Build and Danielle have rightly moved in the direction of opening O1 agent services, and they are in the business of being an agent. And so Build could be the O1 agent who files the O1. I think I'll let Danielle give you the specifics. But if Bill does sponsor your O1, they can inform the U.S. Immigration Service on that initial petition that here are at least 1, 2, or 3 employers we know that might be employing the person over the course of time of the O1. And that would solve the issue of everybody needing to file their own.
Yeah. It's a very interesting time right now for individuals who, you know, are starting companies or potentially working for a company and then have another advising gig on the side, or maybe they're vibe coding and want to start their own company while working. And those individuals might seek out an agent so they can use that same O1 for multiple companies. So that is a scenario we're seeing. We're seeing some companies that actually want to hire contractors. They don't want to give a W-2 employment opportunity and sponsor an O1. So that those foreign nationals can actually use us as an agent and then work for a US company as a contractor. So if you're an employer and you have contractors that are in the US asking you to sponsor their O1s, you could tell them that they could go actually just find an agent. They could work with Build as an agent, and we basically put an itinerary together of their contract work and everything that they're going to be doing in the US, maybe advising here or working as a contractor here. And that becomes the petition itself. So, it definitely has serves a purpose. Jeff has run, he didn't mention, but he's run an agency called Athletes Worldwide for athletes for more than 8 years, I think, is when he got that started. And so we're working off of that blueprint of how to do this successfully with athletes. It's definitely more common when we think of athletes and O1 agents to understand why the athlete would need representation by an agent because they might work for multiple teams, multiple tournaments. And that's something that we are now applying to professionals. So excited to get that program off the ground as well. That's called Build Extraordinary. So we have Build Extraordinary, we have the Build Cultural Exchange, and of course, we have our Build Cap Exempt H-1B fellowship program. As many of you know, we've been running this for 8 years now that we've been sponsoring these cap exempt H-1Bs. It's been Jeff and I have been through two Trump administrations together as we've navigated building this program, which means we've built it incredibly compliantly and crossed T's and dotted I's. I do want to talk through some of that for folks who have not heard of this program. Jeff, if you could just briefly talk about cap exempt H-1Bs at the highest level, and then I want to dig into some of the challenges that are happening now in the space and where this is working well and where we see some of the roadblocks.
Yeah. Well, the H-1B rules and the law limits the total number of H-1Bs every year to 85,000 new H-1Bs. And the demand exceeds 300, 400,000 or more every single year. So the U.S. Immigration Service now conducts an H-1B lottery every March where they pick out the 85,000 winners. And those winners get to move on to apply for an H-1B. And most are approved. Some are denied, which is why they pick out more than 85,000 winners. I think they pick out about 95 or 105,000, knowing that that will be the right number to reach the 85,000 limit. But what about all the other people who either didn't win the lottery or needed the H-1B not during March when the lottery is conducted, but at any other time of the year? Well, it turns out that the law also provides that there should be 4 organizations that never need to enter the lottery. They are exempt from the 85,000 cap, and they can file an H-1B petition at any time of the year. Those 4 organizations are universities, nonprofit organizations that are affiliated with the university, nonprofit research organizations, and government research organizations. So it's great if you need to get to the U.S. and work, and you want to work for one of those 4 organizations, because they can always file an H-1B for you without winning the lottery. Although universities are very stingy, and most universities are not just quickly filing an H-1B for every single person who wants one. They're mostly only filing it for tenure track professors. However, those 4 organizations can always get an H-1B. It also turns out there's another section of the law that says if any of those 4 organizations successfully sponsor an H-1B without winning the lottery, then any company can immediately piggyback on that successful cap-exempt H-1B that never won the lottery. And any company collaborating with one of those 4 organizations can also get their H-1B without winning the lottery. So Danielle and I years ago came up with the Build Fellowship, and how we are and Danielle will tell you exactly about how we are working with nonprofit organizations that are affiliated with universities to help foreign nationals get approved for a cap-exempt H-1B to work for that nonprofit part-time. Also, all for the purpose of having the full-time employer, the one the foreign national really wants to be working for full-time, be eligible to file their H-1B without winning the lottery.
Yeah. This is a great solution for folks right now who are especially filing change of status. So they're here on CPT, OPT, J1s, maybe L1Bs, and they want to change employers over folks who are in the US who want an H1B and were not selected in the lottery. This is the creative solution that Jeff and I have been running for quite some time. Of course, everything we mentioned up until this point is still something everyone should consider, but sometimes you just don't fit into any of those categories, or your employees don't fit into those categories. And so that's when this has become a very helpful solution for many companies across the country. And I'm just showing you briefly, over the years what this really evolved into. We have fellows, these are all foreign nationals who are employed full-time at companies like yours, or potentially, you know, founders themselves, and they work in fields like biology and healthcare, law, data science, computer science. We have hundreds of fellows that all have different specialty fields. We can take Garveet, for example. He is a finance fellow and he launches a project in algorithmic trading. That is his specialty. He does it on his own time. He works remotely and he works full time for Citadel Securities. So he has a full time employer that he works for that has filed an H-1B for him for full time work, but he is able to stay working for Citadel because he is in our fellowship program. And we filed that part time cap exempt H-1B for him. And that's because he works for Open Avenues during that 5 hours a week in this fellowship program. So that's how this works. We're really excited about the outcomes of this program. We have thousands of students across the country who have been trained through this model, and hundreds, more than 500 foreign nationals who have been able to get cap exempt H-1B status through this program. So it's a great option to be able to either offer clients or offer your employees as you move forward. There are some, it's working. We have a 99% success rate, and things are going quite well. We have RFEs like everyone else does. And the barrier this year, of course, was that we are no longer doing this for folks outside the United States who want to come in unless they're willing to pay the $100,000 fee. So that's something that we have experienced. Martha, I see that you want to come in here and ask a question. So I just called on you if you want to hop in. You're on mute. I don't know if you could unmute yourself. I'm going to keep going. If you can unmute and ask that question, feel free to, or you can write it in the chat. So we, of course, with everything going on with the $100,000 fee, there's been a change, and that's why we started filing some J1s for those folks. But we do have some individuals who are here on B1, B2 status. Jeff, obviously, USCIS is looking out to see that folks are coming in and filing for H-1Bs legally. What would you say to folks that are on B1, B2 in the US and potentially want to do a change of status to H1B through a cap exempt H1B right now, which we're seeing a lot of cases, proposed in that way, or potentially, want to come here on B1 so that they don't have to pay that $100,000. Is one okay and one not okay? How would you analyze that?
I think the U.S. Immigration Service will be looking carefully at what precipitated the filing of the cap-exempt H-1B. If you entered on B1 or B2 visitors, they're going to want to see, why did you enter? What were you planning on doing? What was the whole purpose of your trip? And if you have solid evidence that you truly were coming for a legitimate purpose, to enter as a visitor, to visit family or friends, or to attend business meetings or some kind of networking events, and only after you got here did you understand there was something called a cap-exempt H-1B, and that's when you were first put in touch with Danielle, then that's going to be fine. They will look, but they're not going to accuse every single person of committing fraud. But if it turns out that the path is clear, that you had 10 conversations with Danielle and the Build Fellowship before you entered the US. And suddenly you applied for a visitor visa and then you got the visa and you entered. And the next day you applied for the cap exempt H-1B, all to avoid the $100,000 fee. That's going to be an issue. Frankly, Build won't take that kind of case on. You do need to be concerned and you need to have evidence to prove a legitimate entry for a legitimate purpose. But as long as you have that evidence, you should be fine with trying to enter on one status and then change to H-1B once you're here.
Right. And we have a few companies that have come to us and said, "Hey, we have this individual. They've been here. We've had meetings with them over the last few months. We think they're a great candidate, but they're in B1, B2 status." What do you? I mean, that seems like it's a different scenario, right? We're getting, that's when we, of course, want to wait 90 days, ideally, to file. But as you're saying, it's not. We didn't structure this entry without, with the intention of evading this $100,000 fee. So,
Right. Right.
yeah. So that's possible, of course, for some people here on B1, B2 in specific scenarios. That's something we definitely are seeing. There are certain countries that right now have pauses on travel, which is really important. Actually, someone just asked this question, unbelievable timing. But I do want to talk about what the State Department pauses on immigrant visa processing from those 75 countries have meant for us. And certainly what we're seeing, is it worth even bothering to consider this option or any option for visas for anyone from those 75 countries? How are you advising for those folks right now, Jeff?
Well, there's not much one can do if the government has issued a pause because they feel that particular country is incapable of vetting out its own citizens and policing its own laws, and therefore Trump has just decided to put a pause. Like everything else, or pretty much everything else Trump has done, I think the pause is illegal too. And if you really look at the facts of how the pause came about and who it's attached to, it is illegal. Courts are entertaining cases, litigation regarding this whole thing. But until it's resolved, it's going to be very difficult to get around the fact that your country has been designated for a pause. The pause means that that petitions such as H-1B or O-1 or L-1 filed for citizens of that country, you can file them, but they're not going to be adjudicated, which is very frustrating.
They're receiving some of them adjudication on specifically on premium processing cases, receiving requests for evidence of good standing. What you know better because you're receiving them on our behalf. But can you just talk about that? And does that mean that we ultimately could receive adjudication? Do they need this extra layer of information? Is that the intention of the pause? It's maybe a slowdown versus a complete removal of processing for these folks?
All of them are paused. There's definitely going to be a delay. So no one should, from one of those countries, should expect to have very quick action. However, there is a mechanism to get past the pause if you can prove that you are a person of good moral character and you have no criminal record and no affiliation with any political groups who could be seen as a threat to the United States. There is a mechanism for the pause to be lifted in your particular case. Only we have several clients at my law firm who are subject to the pause. Only one of them, after waiting at least 5 months past the processing time, finally received a request from the U.S. Immigration Service to submit this kinds of evidence. Because unless they don't ask, there's no mechanism to submit it. Unless you submit it at the beginning with the petition, which nobody was doing because no one knew about this law that was going to come into place. However, we are entering into litigation shortly to help a few other of my law firm's clients to force the U.S. Immigration Service to issue a request for proof that they are people of good moral character. And while that will be at an expense, it's going to be worth it for the client because I think that's the best way and the fastest way to get past this pause.
Totally. Build is supporting litigation for two folks in our fellowship who were in the application process when this pause happened and they're from Venezuela. So we are supporting that litigation with the companies. We have one of the top litigators, Jesse Bless, working on this with us. And so, because we don't believe there's legal rationale for why this pause is allowed to happen, that's why we feel confident in the case that we'll make to ensure these people were here already. This was a change of status case. They're not coming from abroad. And so we believe there's a good case to be made for why these individuals should not be subject to this pause. And that's the case that we're going to make with Jesse. So definitely stay tuned on how that results. There's also national litigation that's being put together by Greg Siskind and Jesse Bless. So we're waiting to see how that turns out as well. We right now obviously will talk about risks to everyone. We do not take on cases into build without letting you know the timeline and what we anticipate and what's going on in the ecosystem. Some things are unprecedented, but we feel confident that, for those that this works for, we will continue to press forward. So that is the cap exempt H-1B program. A couple questions on convincing employers how to do this. I wish we still had a few of the employers on the call here who have supported employees with the cap exempt program. We should really ask them. But the answer is, of course, one, if you've already proven value to this company in some way, you've interned for them, you've done contract work for them, they understand who you are and they understand your value. That's number one. That's the easiest case to make because you can really just negotiate it into your compensation package and you understand how to do that and they know you well. If you're approaching a company for the first time, it's a bit more challenging. You obviously need to think about it as a negotiation into your compensation package from a fee perspective. I also think that there's a whole other side to this where our fellows in our program are training students within their own expertise. So we've had many companies hire university students who are graduating and have worked with our fellows on these projects before. So there's, many companies pay for recruiters and pay for workforce development programs. And this is actually all built into the Build Fellowship program, which is a very cool additional benefit to the companies. And then you weigh the other solutions, right? What are replacement costs for replacing an employee? What are the costs for actually doing an L1 and sending someone abroad and paying for them to relocate? What is the productivity loss for the company if they do that? And what does it mean to have someone in person? There's financial implications to losing employees that companies need to think about and foreign nationals can help companies understand better. But I do think, this is a program that is meant for top talent with unique skills and niche skills to be able to get employers to use as a tool to stay with top employers, with employers who are trying to keep top talent in this country. So we're happy to be that solution when it works. And my team does speak to folks and we'll send resources, we'll send information. So feel free to reach out to us. We'll send more information after this as well. So that's really everything about the cap exempt H-1B program. As you can tell, Jeff has, really crossed T's and dotted I's with us on every aspect of this. This is meant to be something that everyone can have faith in, that it will pass the sniff test, if you will, from USCIS, and it has year over year, no matter what audit we've been thrown. So that's more about the program. We'd love to hear from many of you to reach out and let us know if you're interested in any of the solutions that we talked about today. You can reach Jeff at gpimmigration.com, and I'm at Danielle at buildfellowship.com. So that's the information for today. We feel free to email us additional questions and we'll be in touch. Thank you all so much for coming. Take care. Bye, everyone.